try and interpret the law in such a way that the state constitution is not violated. Does that make sense? The problem with these cases, however, is that none of them directly takes on the question of what if there's just a direct conflict. In each of those cases, basically, the Supreme Court said, when we look at what Congress was doing when it passed the statute, Congress seemed to be aware that there were state constitutional issues concerned, and they didn't want to trample on state constitutional protections. And therefore, we're going to interpret the law this way. That's what the Supreme Court did in those cases. If this health care bill gets out of Congress, I think it will be very difficult to say that they were interested in avoiding conflicts with state constitutions. I think that it will be the kind of head-on conflict that hitherto has not been addressed by the Supreme Court, at least not in any case that I've seen. And so we can't know exactly how the court would resolve that conflict. Clint thinks that there's a pretty good chance that they would find in favor of state freedoms, but it's a toss-up. As they say, that's why they play the game, right? So I'd like to kind of wrap up this part of the discussion by giving my best shot at reading the tea leaves of what's likely to happen if this bill gets out of Congress. Number one, it'll probably take 2 or 3 years for the issue to get in front of the Supreme Court. Litigation is a slow thing. Even where you've got parties very interested in getting the matter settled quickly, it's going to take a little bit of time to get up there. So my best guess would be it'll be 2 or 3 years before it's in front of the Supreme Court. I think that given the current composition of the court, I really think it's going to boil down to how they decide the Commerce Clause issue. Does Congress have this authority? And the individual freedoms secured under the federal Bill of Rights. The way that the Supreme Court is currently composed, you have 4 justices who tend to lean towards the conservative side of the spectrum, 4 who tend to lean towards the liberal side of the spectrum, and then Justice Kennedy, who sits pretty squarely in the middle and sometimes goes one way, sometimes goes the other. My hunch is that that division will probably hold firm. I think that the 4 typically conservative justices, that would be Scalia, Thomas, Roberts, and Alito, I think that they will probably side against the health insurance mandate, and then the other 4 the liberal justices will probably side with it, particularly on the Commerce Clause grounds. And then I think it comes down, ultimately, I think Kennedy's vote comes down to how the Solicitor General, who's going to be tasked with arguing the case in support of the health insurance mandate, how they answer this question. If the Commerce Clause permits Congress to force individuals to purchase goods and services that they do not want, where is the limit of Congress's power? If indeed you can articulate a limit. In Lopez and Morrison, a similar question was asked, and the Solicitor General could not do it. They could not articulate a limit to congressional power. And I think that's why those cases went the way they did. If the Solicitor General comes up with a good answer, then I think that Kennedy may side, with the liberals on the Commerce Clause issue. The next question, I think, is that of individual liberties. And with that one, I'm intrigued to see how it all comes out. Because as I pointed out, the right to privacy is something that particularly the liberal justices have taken very, very seriously. Under the right to privacy, you can't compel a woman who is interested in having an abortion to tell her husband or her parents about that decision. Essentially, if you can force someone to buy a health insurance policy, you are forcing them to disclose that kind of information to a complete stranger. If we can't compel someone, under the right of privacy, to inform the people who have an actual stake in the outcome of this event, then how can we compel them under this right to privacy to tell someone who has absolutely no stake? I think that's going to be a very difficult question to answer. And that's where I think that some of the more traditionally liberal justices may be really uncomfortable with the implication of the individual health insurance mandate. Now, the trick question to all this is there are at least a couple of the conservative justices who don't believe that there is a right to privacy in the Constitution. Scalia in particular. And Thomas is another one. And so it might be a really interesting situation where you get a 5-4 decision on the Commerce Clause, where you've got the conservatives plus Kennedy against the liberals, and then you have a 5-4 decision on the individual liberty provisions, where you've got a couple of the liberal justices, a couple of the conservative justices, plus or minus Kennedy, and then a couple of the conservative justices and a couple of the liberal justices on the other side. So it could just be a really, really unusual outcome. But my best guess is that the Supreme Court will not permit the individual health insurance mandate to be applied against people. So with that said, I am now happy to take questions.